What's new at the Appellate Division? Stay tuned for this month's Legal Scoop. This month we got Mondesir v. Allied Universal, which is a really interesting case involving a question of whether an accident occurred in the scope and course of the claimant's employment and whether the fall was caused by idiopathic reasons. So the facts of this case are pretty straightforward. The claimant went to work and he had to change into his uniform, which was located in a locker in the basement. And he slipped and fell down the stairs to the basement face first and was discovered about an hour later unconscious and partially paralyzed. So the carrier here argued that the accident didn't occur in the scope and course of the claimant's employment and that really it was an idiopathic fall. However, the issue here was that while the claimant wasn't clocked in or anything like that, he was on the premises. So it's sort of implied in the decision, although not expressly discussed, that the accident did at least technically occur in the scope and course of employment. So the issue of an idiopathic fall is basically an unexplained fall or something that's explained by a condition that's not related to work in any way. A lot of times it'll be someone who faints or someone whose knee gives out while walking. And the general rule is that if you fall straight to the floor, it's not necessarily compensable, because what happens is when the carrier proves that there's an idiopathic fall, it shifts the burden of proof to the claimant to prove that their injuries resulted from a risk incident to their employment, which typically is some sort of work-related instrumentality. So that could be a desk. A lot of times it's actually considered to be stairs as well. So that could have been an issue here. However, that wasn't really the issue here, because the carrier failed to clear the first bar for arguing idiopathic, which is some sort of proof that the fall was idiopathic. And this is something that I think sort of glossed over a lot and a lot of people aren't really familiar with, which is that you have to find a way to prove that the fall was idiopathic in the first place before you can shift that burden of proof to the claimant and consider whether the injuries resulted from a risk incident to their employment. That can be done by an IME, it can be done through cross-examination of the treating provider, and it can even be done in some ways, or at least bolstered, through the testimony of the claimant and any employer witness. Say the claimant says, yeah, I don't know what happened, I just, all of a sudden I fell. So what do you do if you think you have an idiopathic claim on your hands? It's definitely something you want to refer to defense counsel, but then there needs to be an actual conference with defense counsel to discuss how you want to prove that it's idiopathic. So it's good to get all your ducks in a row with these type of cases and to get as much information and as many facts as possible that surround the fall. That's how you can prove that it was idiopathic and shift the burden of proof to the claimant to prove that their injuries resulted from a risk incident to their employment.